Hello, everybody. Good morning, good afternoon, good evening, wherever you are. I'd like to welcome you to this Refugee Law Initiative conference panel session on diverse scenarios. Does the Refugee Convention matter for the legal protection for refugees? My name is Tonny Raymond Kirabira. I'm a lawyer and PhD researcher based at the University of Portsmouth in the UK. But I am also a research affiliate with the Refugee Law Initiative. It is my honor to welcome you again to this panel session. Again, asking the question of, does the Refugee Convention really matter for refugee protection? The papers on this panel shed light on this key question through an assessment of how the Refugee Convention has been or could be used or even developed legally and as a matter of policy in diverse range of national contexts. Moreover, the analysis addressed two of the most challenging but under-researched refugee outflows of recent years, the Rohingyas and the Venezuelans. Thus, the first paper will explain how other sources of law, particularly non-state local customary law, rather than the convention, drove the protection of the Rohingya refugees in Indonesia. In a similar vein, the second paper suggests that the convention is in itself not a sufficient source of law to protect Rohingya refugees in India. The third paper, finally, will ask a novel question about the relevance of the convention in protecting refugees from Venezuela in small post-colonial states in the Caribbean. The full details of these four papers and the presenters that make up this panel can be found on the conference program. At this point, I will go to the house rules for the panel. Our speakers will start off the day by presenting key perspectives on the components as has been outlined, after which we shall open up for broader discussions, questions, but also comments from you, the participants. Each of the presenters will have 10 minutes, which I have asked them to enforce strictly. For the rest of the participants, please would invite you to type questions in the chat box, which will be addressed by the panelists. There will be ample time to discuss and reflect upon your comments and questions. So please keep an eye on the chat box. Another rule to take note of is to keep our microphones on mute unless we are presenting. The same with the videos. Unless one is presenting, it is advisable to keep mute. As the session is recorded and will also be posted on the Refugee Law Initiative website as podcast. So to start off the presentation, we shall turn to our first speaker, who is Fitria, who will be presenting on the legal pluralism and refugee protection, looking at the case study of the 2015 Rohingya refugee crisis. Fitria, you have the floor.
Thank you very much, Tony. Thank you for having me here. So I would like to share my presentation. Okay. Sorry. So the research that I would like to present is part of the finding of my PhD thesis in the University of York, and currently funded by the British Academy. We, in Martin Jones, the SDBI, and 2 other colleagues, we are conducting the collaborative research that aims to explore the local approaches to protection in Southeast Asia. So I would like to contextualize my research into 2 points. First is that the Eurocentric characteristic of international refugee regimes. If you recall the drafting process of the Refugee Convention, it revealed the dominance of European states over others. For example, the Indian delegation's suggestion to include their refugee into the definition of Refugee Convention was refused. This led to what Sarah Davis describes as Asian rejection. This is one way to understand why many Asian countries, including Indonesia, haven't ratified the convention until now. Secondly, the protection challenges through the restrictive and punitive measures put in place in both Global South and Global North countries to stop the refugee entering their respective territories. As we all know, they're one of the most persecuted ethnics in the world. Hundreds of thousands of Rohingyas have fled their own countries of residence, Myanmar, to seek protections for neighboring countries. Mostly stranded in Bangladesh and Malaysia, some of Rohingya will end up in Thailand and Indonesia. It was in the spring of 2015 that the world's attention focused on the Achenese fishermen who rescued nearly 1,000 Rohingyas stranded in Andaman Seas. The Rohingya were also spontaneously helped by local inhabitants who provided their basic needs. This is where the Rohingya were stranded in Aceh. Aceh is the northern end of Sumatra Island, and Aceh is one of the provinces in Indonesia, and it has been granted an autonomy to some extent to apply Sharia and Adat or customary law. So my research looked, at the significance of law in refugee protections. The meaning of law is not only limited to state or official law, but what I call as non-state made law, such as customary law and religious law. Therefore, the research used the lens of legal pluralism in order to understand the practice of law on the ground, and also at the same time, this research also used the legal consciousness to understand what people think and do about law. So for this reason, I borrow Menski's theory about 4 types of law that are recognized, widely in Asian and African countries. And Menski also highlights the coexistence between this law. So not only the coexistence, Benda Beckham, for example, also demonstrate their contestation between Adat law, state law, and Sharia. Then they describe as complementary equivalence and their superiority. So I also acknowledge Selby and Ivik's, works on the, common place of law, especially with the way I explore, the ideas of laws of the participants. So, there are very rare, research that link legalism and refugee protections. So there are some research that I show in the PPT about that links, and then with regard my research, this is socio-legal research, and I conducted the research for nearly 2 months, both in Aceh and also in Jakarta. So I did also interview those who had experience in rescuing and aiding the Rohingyas, and also I did also focus groups for different focus group in 4 different locations. And there are some findings that I would like to share. Some findings of my research. First is about their motivation. So it struck me. I mean, before I went to the field work, I assumed that okay, I think the motivation is as simple as that. It's just humanity. But when I asked them and I knew the answer, I was surprised, because the motivation were very diverse, and maybe I can quote some of them. For example, Well, maybe because we have some concerns that the same destiny. Both of us had undergone a very traumatic conflict. This conflict made the Acehnese easy to put themselves on the refugees' shoes. This is one of the interviewee from the member of the Acehnese movement, and the other is from the fisherman, for example. He said that it is our duty based on our customary law of Acehnese that whoever get troubles in the sea may seek for help from us, and it is a must that we help them. And when I asked about what is the law, also like the answer very diverse and also complex. And I would like to highlight two of them. For example, the first is about the law is there to manage anything. So it is more, what is it? Whether to have more justice, prosperity, not only from the state. As a Muslim, we've got Sharia, and the other interview. I remember very well, he didn't like respond. Even he didn't know what the word law is, because I interviewed in Bahasa, in my language. So when I asked law, he didn't know what is the law. I don't understand. He knew only like customary law as law, adat they call it. So there are some findings of my research. First is as I said before, like everyone, most everyone has given more than 2 accounts, and I would mention that they are legally driven motivation and non-legally driven motivations. And also noted that the actors' background, mainly for Acehnese, shape their accounts and responses to the crisis as they hold more than one identity. So, for example, the fishermen also at the same time member of the fishery community and also member of the religious community, as they also active in the congregation in their neighborhood. And also, like I noted that about the role of, especially adat law, including adat law of the sea, customary law of the sea, and also Sharia, are very significant in shaping the actors' response to the Rohingya refugee crisis. Importantly, the obligatory norms to rescue those found in distress at sea has been preserved for a very long time, and as norms have been passed on through families and also maintained by the fishery communities. Similarly, there are norms of Pamula Jame. It is Acehnese language, and it is translated as rules of honoring the guests inspired by the Sharia, has been preserved and passed down within adat or religious customary community. So if I link the between different normative orders, there are some findings which is, I think, very interesting. For example, when I asked about their motivation in the focus groups, like the answer was very, very elaborative. And then, for example, some answer I noted here, pesong gasih badan kaya, when they said that hide your poverty, then you look rich. Show them that we are capable of serving guests, although in reality we are not rich. That has become something special among the Acehnese. It has been implanted in us. It's quite paradox, because Aceh is one of the poorest province in Indonesia. And when they talk about Pamle Jame, the rules of honoring the guests, we said that it was implanted in ourselves and it was our ancestors' heritage. And also one of the FGD participant also linked the customary law with the Sharia, when he said that the guests will be given priority. That's Islamic way. That's the way the Prophet Muhammad applied when he served guests. The Prophet would prioritize whoever needed the food, even though he himself didn't have much food to share. So there is no difference between what the Prophet taught us and what we have practiced in our society. So the relation between adat and Sharia, for example, is not only complementary, equivalence, or superior, but it can also be overlap. This is something that is not kind of mentioned in, for example, Benda Beckham's theory about the contestation between this legal orders. And with regard to conclusion, I would say that in contrast to the mainstream research of the refugee studies, my research applies as a bottom-up approach. So for in my view, the concept of law is not only confined to state or international law, but includes non-state made law, such as adat or customary law. The empirical findings reveal that people's understanding of law is plural and complex. Moreover, the main driving force behind people protecting refugees is neither international nor national law. So the finding also suggests that we cannot underestimate the location itself in which the refugees are stranded, then are rescued and held by mainly by local people. A study in the specific context into the protection of Rohingya refugees in specific regions such as Aceh adds a contribution in the literature. The last thing is about Werner Menski and also Benda Bacon's idea on the relation between law and other normative orders. They are incomplete because they didn't mention because the relation that is not only superior or complementary or equivalent but also can be overlap. I think it's enough, Tonny. So I would give Tonny back to lead the discussion. Thank you.
Tonny, I think you're on mute.
Thank you so much, Fitria, for that powerful discussion. It really touches on the gist of the session about diversity. You have reminded us of the need for legal pluralism, not only in international law, but also in aspects of refugee understanding, but also human rights. So thank you for that. Turning to our second discussion, which touches on the laws making and breaking of refugees, Lawfare and Rohingya refugees in India, which has been prepared by three excellent presenters and scholars, Aman and Ishita Kumar from OP Jindal Global University in India, and Nayantara Raja from Asia Dalit Rights Forum, India. And the speaker will be Aman. So Aman, you're welcome to take the floor.
Thanks, Tony, and thanks, Fitria, for your presentation. I'll not take a lot of time with the preliminaries, and I'll jump right in. So just give me a quick minute to share my screen, and I'll just start off. Yeah. So, I mean, just starting off with the slide that stares at us from, what stares at us is one of the recent decisions of the Supreme Court of India in the deportation matters of Rohingyas who are stationed in the Indian administered regions of Jammu, which is again a contested area, but we're not going to talk about that right now. But essentially the question that the Supreme Court sort of frames the deportation question is framed under constitutional law. And it's interesting how it sort of says that for Rohingya refugees, being foreigners, they do have Article 14 and Article 21 rights, which are the right to equality and the right to life under the Indian Constitution. But an interesting framing by them is the right of not being deported comes actually from Article 19, which is actually only reserved for citizens. Now, this framing of law becomes very interesting because the choice of deportation can also come under 14 and 21. But that is not our discussion today, and we don't take a constitutional law lens, but we want to understand what this framing of the law is. And to do that, I think it's important to, I don't want to spend a lot of time on discussing the context in India in terms in which like Rohingya refugees are sort of living today. But it is important to highlight, like at least, the pictures for those of us who are not aware with the context. It's very clear. Again, it's from the region of Jammu itself, like a newspaper front page and a billboard sort of talking about Rohingyas having to leave Jammu. And that sort of also sums up, in a sense, what Tendai Achume talks about the in-group and the out-group. And the out-group which is the refugee in this situation, faces actually has intersectional identities, and all these intersectional identities technically have some or the other prejudice attached to them. So I'm not going to I don't think I'll be more articulate than Tendai when she explains this in-group, out-group, and the various kinds of prejudices that are prevalent. But for any of us who've been following the news or these pictures are evident, you will be able to understand what we are talking about. And I'm going to show you a few more instances of what our premise is. Now, based on, our central argument, and let me not take more time on that, is essentially to show that considering, and we've been speaking, we've heard multiple speakers talking about the Eurocentric nature of the convention, and even outside the conference for that matter, if we read Tendai Achume, Itamar Man, Saila Ben Habib, and many other scholars who are talking about the limitations of the Refugee Convention in this populist era, it's very important. And that is what, we are not saying anything new or out of the world, but we are trying to show, what others say that, they may call it that like refugee law, individuals or states are finding cracks in refugee law. What we are saying that they are actually using refugee law. So 2 points of the central argument are that India, despite being a non-signatory, centers the refugee identity or the lack of it for its own benefit, uses the very logic, language, and the legitimacy of international refugee law and deploys it against the Rohingyas. Now, to do that, I think I just want to quickly, not necessarily spend a lot of time on it, but between these two popular essays and drawing from them, like one is by Hannah Arendt and one by Agamben, which talks about who are refugees. And in the middle of it, Itamar Man sort of in 2014 sort of talks about in his excellent essay called Refugees, that there are central issues with the idea of looking at who a refugee is. Because the convention, for that matter, creates an impervious barrier between the categories of a refugee and a citizen, and that becomes more acute through the silences in the processes that are, when we look at the refugee status determination processes, that become a lot more acute. Again, using that same logic, rationale, we often find the securitization, like right now, at least, for those of us who've been following popular discourses wherein populism is one of the reasons why states are finding certain justifications under refugee law, as Saila Ben Habib sort of herself talks about, is the creation of 10,000 Guantanamos or deterritorialization. We see that Refugee Convention itself is being deployed. Now, let me just quickly jump into this issue of how we look at this problem vis-a-vis India. And I say this is, we've used the Rohingyas, but I'm going to talk about this there is a general problem in terms of the ideation. So India, despite not being like a signatory to the Refugee Convention, it is very interesting. And this is another recent case that came on May 3rd, 2021. And it is one of the most progressive cases that allowed for, recognized a right of non-refoulement. But it's very interesting that even the most progressive cases sort of use the same language and vocabulary, that we have to differentiate between a migrant and an asylum seeker. And you have to be, you cannot be a migrant for you to be able to get protection. And therefore, there is a fundamental problem in the most progressive iterations, because India, for that matter, had the potential or the possibility of using a constitutional law framework in addressing this refugee law question, but despite that, it refuses to do so. And it's very interesting for those of us who feel that India has not been has not signed the Refugee Convention, but has been utilizing this very rationale of Refugee Convention for a very long time. And case in point is what I show you in front of the screen are the long-term visa provisions, which use the very same test. Very soon, I will jump onto certain instances, and let me quickly jump onto the instances in terms of which drive our central point. And I want to talk about how the Supreme Court of India does exactly what we were talking about when we talk about a central argument. Again, I think with the paucity of time, I may not have the opportunity to cover all instances, but let me just try and do the best job of it and quickly sort of cover a few instances to make our points very clear. So the idea is, if you look at the recent decision of the Supreme Court of India, which talks about the idea of the Refugee Convention, there is a centrality to the refugee identity. Now, the centrality to the refugee identity makes it a very interesting idea, because, say, for that very reason, if you see the snapshots of the court proceedings on the side, of course, they're borrowed from Twitter, but most accurate accounts as they could be. You can see that the customary law protections or the other protections given under human rights conventions are being denied. And if you see paragraph 12 of the decision itself, it's very clear that the only focus of these individuals, like what the court is trying to do here, is asking, are they refugees? But we've not signed the Refugee Convention, no other law matters, and therefore that is good enough. So the idea is you center that refugee identity, and that is exactly what the Refugee Convention or all other states today are doing. Secondly, it's also very interesting to take note of the same parallels of security concerns, and which becomes very interesting again from the very decision. If you take a look at paragraph 14, which talks about two major concerns, both related to national security and threats, and the court concludes using the language of therefore, saying that, I mean, because of these national security concerns, protections cannot be given. And that brings me to another interesting point, because I mean, India has historically used questions of consent as a basis of drawing legitimacy to repatriate. This happened with the Sri Lankans, and this is again happening with the Rohingyas, because in the previous case, where the first set of deportations came before the Supreme Court of India, in the Zafarullah matter, the Indian government said that these people have consented to go back, and these people were in fact, interestingly, detained. There was no access to UNHCR, lawyers, or anybody, but the government of India just came and said in the court that these individuals have consented to go back. And there was no assessment of this consent. So the very idea of using the very principle of consent to make it a legitimate return is another thing that is sort of happening vis-a-vis the Indian sort of context. Now, let me again, I don't think I will have a lot of time to talk about the administrative angles, but again, vis-a-vis the repatriation concerns, there was, say, for instance, there's an effective tracking of the Rohingyas, and I mean, they're made to fill forms in the Burmese language, only, I mean, to say that we are like, you know, collecting this data for them to be sent back to Myanmar today. Again, I don't think I have a lot of time to do this right now or effectively talk about it, and I can address questions if at all they're required. But there are two instances that I want to quickly point out before I move to the conclusion, which is first and foremost, India, again, as I told you, has been using this language of refugee since long. And if you see very carefully in I mean, if any of us have been following the Citizenship Amendment Act debates in India, very much this debate around citizenship revolves around refugee status, because it tries to protect certain religious identities, essentially barring Muslims communities from other countries to come into India and claiming certain benefits. Again, this is a refugee protection clause, which is couched as a citizenship a protection language. And if you see, interestingly, when the Citizenship Amendment Act is challenged, the government submits to the court that there are certain kind of refugees and there's certain kind of migrants, which is again going back to the very idea that the convention itself allows for these cracks. It was designed for these cracks, and therefore it is a concern. And I think let me just quickly come to the last instance, which is about the idea of cherry picking of refugee law instruments. And this is exactly our keynote speaker today was also sort of talking about the very idea of using refugee law like the GCR and other such instruments against the Rohingyas. Now, if you take a look at para 7 of the GCR, it says very clearly that you support conditions in countries of origin for return in safety and dignity. And to do that, it's very interesting that an Indian government has signed an MOU with the Burmese government to start this Rakhine State Development Program, where they're building houses, showing that somewhere Rakhine State, I mean, through this development, it will become safe tomorrow for you to go. So it's using, again, the legitimacy provided by an instrument to repatriate. Now, what we see is, of course, nothing novel again. I mean, borrowing again from Oboya or Okafor and other individuals who've spoken about the importance of solidarity. And I want to sort of quote these two Rohingya activists who've written a very, very compelling and a powerful piece on Twitter very recently. And they talk about this very idea that we must see, for instance, to understand, I mean, we need to, I mean, I'm not saying that the Refugee Convention must be done away with. That's not a simplistic argument that we want to make, but we need to question it. We need to see that there is, as a previous speaker just spoke about, that it requires some sort of a pluralistic strategy to it. And one of the things that is very fundamental in any populist space is to recognize the ongoing struggles, recognize that there is an individual who may have come fighting for some sort of a cause and has certain beliefs. And if you accord that respect, only then probably can we be able to sort of look past the concerns of the Refugee Convention? I'm sorry for having rushed through most part of it, but I'm hoping I've addressed some of the concerns, but we can take more during questions. Thank you so much. I'm sorry if I've exceeded time.
Wow. Thank you so much, Aman, for that great discussion. It has been insightful for people interested in the law, but also the ones interested broadly in issues of the Constitution, but also international relations. Very, very interesting indeed, the developments coming out of India. And I'm sure there will be a lot to debate on that. So for our participants, please be reminded to make use of the chat box. We shall have ample time to discuss. So any comment or any question, please use the chat box. Finally, we shall go into our last discussion by Dr. Natalie Dietrich Jones from the University of West Indies in Jamaica, who is going to discuss the possibility for maturity, the 1951 Convention and its protocol in post-colonial small states in the Dutch Caribbean. Dr. Natalie, the floor is yours.
Thank you, Tony, and thanks to the previous presenters. Are you hearing me?
Oh, yes, we can.
Okay, I'm going to share my screen, and I wanted to say very quickly that, as you pointed out, I'm coming at this from a very different lens, geographically, but also from the notion of size, which I touch on in my presentation, but we can speak about the potential for responses in small island developing states. So I am using these 5 concepts. I'll begin with the letter P to try to explain this issue surrounding inconsistencies in ratification in non-sovereign jurisdictions in the Dutch Caribbean. And I wanted first to start with the peculiarities or the special characteristics that define these states. So there are 20 non-independent countries in the Caribbean, and the preponderance of, I'll use the term mix in this region, has led to the question of whether or not we're in a post-colonial era. Now, Corbin, whose work I rely on, has, in these discussions with me, indicated that the Dutch Caribbean is perhaps the most complicated case because the Kingdom of the Netherlands, as we know it, is actually constituted by a metropole state located in Europe, 3 autonomous countries in the Caribbean, so Aruba, Curacao, and St. Martin, and 3 integrated jurisdictions, which are referred to as the EES countries, Bonaire, Eustatia, and Saba. So the constitutional arrangement between these 3 different entities is outlined in what is referred to as the statute, and essentially there are 2 layers of government. There are national governments, and then there is the kingdom government. Well, because of time, I can't go into detail, but you need to just understand that there are these 2 different layers, and I will explain what the implications are for migration policy in a bit. So the Kingdom Charter has 3 articles of relevance to this issue surrounding migration from Venezuela, the current experience. And this has been outlined by Amnesty International, but also scholars doing work on migration from Venezuela to the Dutch region. And I wanted to focus for this presentation on Part B of Article 3, as well as Article 43, since we're looking at the ratification of the 1951 Convention, as well as the protection mechanisms in place for persons who might be seeking asylum. And so what I wanted to show with this slide is that the UNHCR has described the Venezuelan migration crisis as on the scale of Syria. Now, this was in 2018, so 2 years ago. I would say maybe in the heights of emigration from Venezuela, and just probably coinciding or just before the borders would have closed with Venezuela. Now, there are some inconsistencies on this slide. I don't know if you are seeing it, because he uses scale of Syria, which suggests a high number of persons are moving from Venezuela to the Dutch Caribbean / Southern Caribbean, because it's really 4 countries in the region. And if you look at the bars for Aruba and Curacao, we see only 17,000 persons of concern in Aruba from Venezuela and 17,000 in Curacao. Now, the reason that they say the scale of Syria is that these countries are all classified as small island developing states. And one of the features of these states is that they have small populations. And so that figure that you see there that represents legally resident citizens, persons who would require international protection, who want to claim asylum, that is roughly 10 and 16% of the populations in these countries, respectively. So despite the small numbers comparatively with the rest of Latin America and the Caribbean that's experiencing this migratory crisis, the figures are small, but are bound to have a significant impact on these countries. And I wanted to contextualize this current wave, if you will. I don't really like to use those words, but this new movement from Venezuela and historicize previous movements, because refugee movements are not new to the Dutch and wider Caribbean. Political refugees have sought protection in Aruba and Curacao in the 19th and early 20th centuries. In fact, in Aruba once, so many Venezuelans came that the whole island was, all the homes, the governor's mansion was overrun with political refugees. And I'm not sure many persons would know, but Sephardic Jews are a well-established community in Curacao. They have, I think, one of the largest contingents of this community in the hemisphere. And so the point of this is that the movements are part of a larger pattern of internal and external refugee movements. But what is surprising is that even though we have this history of movements, that there is a weak protection environment for asylum seekers in this region. And that's basically what I want to try to explain in this presentation for non-sovereign jurisdictions in the Dutch Caribbean. So you're seeing on the screen the depository notification here for the territorial application of the protocol relating to the status of refugees on the integrated jurisdictions of the Kingdom of the Netherlands. The protocol also applies in Aruba, but neither the convention nor the protocol are have been ratified by Curacao and St. Martin. And so what essentially is in effect is an inconsistent territorial application of both the convention and the protocol in the Kingdom of the Netherlands. One of the reasons for this is that the convention preceded the acceleration of decolonization in the 60s. And this discussion applies more broadly than the Dutch Caribbean. In the context of the Netherlands, they did not apply the convention to their colonies, and I would say immediately. And we saw there that it was only in 2011 that the protocol was applied to the BES countries. And with Suriname, which was a colony before it became independent in the 70s, the convention had also been applied to Suriname. And so there's this paradox of the colonial experience in the Dutch Caribbean, where the convention and the protocol are being applied in some jurisdictions and not others. And so this has resulted in a lack of incentive for these countries to develop a refugee policy framework or legislation, resulting in this weak protection space that I mentioned before, but also dualism in responsibility over migration matters. So if we go back to this earlier slide in terms of who is responsible for what within the kingdom, migration is entry and exit is managed by the respective countries, but the general conditions for admission and expulsion are held, that responsibility is held by the kingdom. And also in this region, the patrolling of the territorial waters and their borders is actually a joint effort and initiative. What this means, therefore, is that we have different layers of protection in Aruba and Curacao, which are the countries that I'm focusing on. So notwithstanding this inconsistency in ratification of the convention and the protocol, we see that there are other means of protection through the European Convention on Human Rights and also the Convention Against Torture. And the reason that I'm highlighting these in particular is because of my emphasis on non-refoulement. So in this article that came out on this blog rather recently, I had made the point that there is an interdiction, detention, and deportation policy in the Dutch Caribbean. Now, it's a little bit more nuanced than that. In Aruba, the border remains closed between Aruba and Venezuela, and I can go into some detail about why that's happened in the questions. But Aruba has retained the border closures as a means of preemptive refoulement. While in Curacao, what they've been doing is actively detaining individuals who attempt to cross into their territorial waters and to enter Curacao through clandestine means. This policy came to the attention of a number of human rights organizations, international organizations. Human Rights Watch and Amnesty International both condemned this approach taken by, their focus was on the government of Curacao in particular. And because of the non-ratification of the treaty, they have been encouraging as a first step the ratification of the 1951 convention by this country. My argument, however, is that the ratification of the convention or the protocol is actually only a first step. And it is certainly not a sufficient step to secure the protection of persons seeking asylum or persons in need of international protection in these jurisdictions. And so the persistence of colonial relationships has prescribed the capacity of NICs to ratify the treaty. And because of this prescription, we actually need to look outside of the treaty for solutions. And this matter has been considered by different advisory committees within the Netherlands. And what was recommended was harmonization of the refugee policy across the kingdom's constituent parts, which I say is necessary but not sufficient. I'm more interested in integration of refugee protection in the human rights framework of the Dutch Caribbean. And what that would mean is essentially a recognized and institutionalized system for processing of persons seeking asylum. So as it obtains now, certainly in Curacao, there is a backlog of cases because they took away the role from from the Red Cross, which was working in conjunction with UNHCR on processing claims, and handed it over to a government department. But what has effectively happened is that there's this backlog of claims. With the closure of the border, a number of persons remain in detention, and that detention exceeds the period of what is considered to be lawful detention. So I'm gonna stop there. I've touched on a number of things that I think persons may want additional information. It's actually a very complex scenario. I haven't attempted at all to address the geopolitical issues which have influenced the management of migration, but I'm happy to speak to those in the question and answer period.
Wow. Thank you so much, Dr. Natalie, for that great discussion. It's been quite informative, but also really gets us to think about innovative ways of protecting refugees. Like you have clearly stated to us that a human rights-based approach at this time would be really, really critical. So thank you. The discussion is really novel, and we look forward to also getting to hear more from the participants, but also probably the blog article that you mentioned, if you would be free to share at some point, maybe in the chat, it would also be great. So at this time, we shall get into the Q&A, and I would just ask the presenters, the 5 presenters, to be free to look through the chat and respond to any. But I will start with the first one, Fitria, and also if I could add something that I omitted by error, the first presenter, Fitria, is from the State Islamic University, Syarif Hidayatullah in Jakarta, in Indonesia. So that also speaks a lot to her powerful presentation on legal pluralism. So please, 5 minutes to respond for each, then we shall get into a second round. So please, Fitria.
Yeah, I think there's one question directed to me. It's about about the camps, the legal pluralism in camps. Then I would say first, like actually there are two pace of the reception of the Rohingya in Aceh. First is like immediate aids, which was like provided by the fishermen and also like local inhabitants. And the second phase is the receptions where the Rohingya stay in the shelters. And when I didn't mention in the presentation, actually I also like use the one another framework that I use is about the relation and the international refugee regime with the neo-colonialisms. This is how I can explain the situation in the refugee camps or shelters. There are tensions, especially between the NGOs who manage the shelters in one hand, and also at the other hand is with the UNHCR member staff who in many occasions when I came across with the either interview or in the on the FGDs, the NGO especially mentioned many times that they are very arrogant and it's like they didn't recount our efforts. Maybe for your information, that is quite different. In the shelters in Aceh was built by the NGOs. It was not by UNHCR because they didn't have money to. At the very beginning, they said to the local governments, we don't have money. So the NGO who work hand in hand to build, and also like at the same time they also stay there. Most of their time staying with the refugees, and the things that maybe because I translate the behavior that they kind of underestimate, the local norms, and also like the local people. They say that it's the UNHCR member staff. They said that okay, it's our affairs. At the very beginning, they say that it's our business. This is you're supposed not to be here. We can say that, and then but the NGO kept like, well, we here we don't have law. So I mean, like the governments itself, they don't have the national law and also local law on how the refugees should be managed. So they were confident, and fortunately the local government on the NGOs side, so they said that they know that internet agency, they don't have a lot of money, and also like at the same time NGOs have given their contributions. So and local government said it's like it's better to let the NGOs here. So the tension that I would like to describe, one of them is like about, for example, the child marriage, between the Rohingyas in the shelters. As the UNHCR staff members said that no, there's no child marriage. You're supposed to not doing this. It's illegal. It's against the like they said about child conventions. You're still underage. It's not legal to get married, and then it's always like then at the same time the refugees, like they often share their view, etc., with the NGOs who supposed to who have the same kind of opinion with the refugee, that okay, it's better to get married, even though it's in the we can say the underage, but instead of like doing the free sex between them. So it's so this is one of the tension. And then when the local government went back to the UNHCR, so what should we do? And then the UNHCR said, we don't have like we don't know how to deal with it, just up to you. And then the local government was very confused, and then let the NGO, and then like to kind of invite we can say the one who responsible to kind of a priest, or we call that in Islamic we call it ustad, who kind of valid the marriage between them. This is one of the examples. So the tensions there are tensions, but I can say that it's more likely that refugees are more feel secure with the in the side of NGO because they have like some values and norms rather to like with the UNHCR stuff. But in two settings, because there are two shelters, different shelters. In North Aceh, it was very difficult to kind of to like mitigate the difference, but in different area in the Langsa, it could be managed by the local government. So who I can see that this is also another side of the of the Rohingya crisis, where the two governments have different style of managing the conflicts, and the other one is quite at the end of the day, the UNHCR and also like the local NGO, they could get along each other. But in the first setting, it was still difficult until the end. So this is like the kind of the brief overview about what was happening in the shelters. So that's I think enough for me, Tony. So I will give.
Okay, cool. Thank you. And now the second presenter.
Hi, thanks, Tony, again. There are two very excellent questions, and I've just divided them into three sort of sub-questions, and I'll try and address them. The first question that Sritapa asks is that whether the judiciary is actually guided by this citizenship and non-citizenship paradigm and somewhere. I actually want to sort of begin before this guiding factor. I want to actually, like, our point that we are trying to make is it's actually restraining it. Right. So if you look at the most progressive sort of, when you looked at Nandita Haskar's case, wherein they said that the refugees do have like certain protections in India under the constitutional provisions, etc., etc. I mean, even in that iteration, for that matter, it was again whether you're not a migrant and you are a valid refugee, and only then do you claim to sort of get protection. The problem of this restraint actually comes not just from the rationale of the Refugee Convention, which is one of our conclusions, but it is also somewhere imbibed very much in our Foreigners Act in India. I will now come to to address your question more directly. By the looks of it, yes. Like for all of us who train in sort of realist school of thinking, for that matter, it is rather evident to a large extent that judiciary is not operating in vacuum and pretty much is guided by the same biases and prejudices that exist. The second question you ask is a rather difficult one for me to answer, which is about where do you place refugees, Rohingya refugees, who are at times considered as illegal immigrants, sometimes stateless, sometimes terrorists, sometimes X, Y, Z. There are multiple adjectives. Again, I think there is a word of, how we look at it, for that matter. I think it's very interesting because I don't think that the law provides for all definitions, and that is what we are trying to sort of account for, that there is, as Tendai Achume sort of talks about, that there is a multiple sort of identity that is attached to a refugee, and this intersectional identity needs to be taken into account. Law currently doesn't do it. But that brings me to your third question, which is also tying somewhere to Sarah's question as to what are the safety nets or litigation strategies that are possible. Again, a word of caution before we jump into it. To look at international law, look to international law. There has to be some, at least this panel has been, and all of us have been sort of somewhat suspect about the origins and the roots of the convention. And if we have heard Professor Chimney yesterday, there are certain external factors that need to be taken into account. But having said that, though we critique the convention, when it comes to actually litigation efforts, we need to use some strategy somewhere, wherein international law plays some strategic role or tactical role, as certain scholars like John Reynolds, Nora Irakat, and many others would point out. And to that end, I feel that Indian Constitution, for that matter, provides for enough safety nets that are available. The problem is the viewpoint today. Say, for instance, if the Supreme Court, for that matter, looked at, say, for instance, answering or addressing Sarah's question first, there is India follows this tradition that is usually customary international law is applicable in domestic courts as long as it does not violate any local law. And various courts in India have already held that the principle of non-refoulement is actually a principle of customary international law. And in any case, even if we do not want to agree to that, assertion, there is another argument, that is India has signed on to various international human rights conventions, which very much have a role to play in local courts. And there is ample amount of jurisprudence to support that. Now, the idea is somewhere to root it in that. Say, for instance, if we take a look at, again, it seems like I'm a fan of Tenda Yachume. There is all the reasons to be, but Tenda Yachume has, for that matter, also filed an amicus brief in the Indian Supreme Court, sort of saying why multiple conventions are applicable in this entire context. And the Indian Supreme Court, applying the constitutional principles, interpreting international law into these constitutional principles, refused to hear the lawyer that was representing this brief. So that becomes interesting. So I think somewhere we have to realize that we have to start looking at human rights instruments, also recognize that human rights instruments have their own limitations. But hoping that sort of answers the question, I'm just going to let my colleagues, Nayantara and Ishita, jump in if they have any other questions to add. Any other sort of suggestions.
Thanks, Aman. I think you do have one more question on solidarity, but before that, before you take that up, I think I'll just quickly jump in to add to your response to Shritapa's question on where would you intend to place them as part of a wider litigation strategy. And I think it's the very idea behind the strategic litigation efforts in order to prevent the deportation of Rohingyas since 2017 in India has been to argue that they are persons under Indian constitution and therefore are entitled to right to life, which is not only meant for the citizens of the country. However, like Aman was mentioning in his presentation in the very beginning, the centrality that has been imputed to the refugee status, or rather a contested refugee status to Rohingyas amidst the populist forces in the country at the time being, it's the very identity of refugee has been weaponized for them, and they have been stripped of their very basic identity as even persons under the constitution. So I think the idea still continues to be in order to get them the rights that they are entitled to as individuals, as humans, and also therefore bring in the application of the International Human Rights Conventions as well. Back to you, Aman, for your last question.
Maybe we can have Tonny I can cover this in the second rounds.
Thank you. Thank you. Now we shall go to the last speaker to respond to the questions. Then after we shall have a second round of questions. Thank you.
Thank you. Thanks for the question, Sarah. She had wanted to know whether once a treaty is ratified, if it's the responsibility of the autonomous countries to implement in domestic legislation the various commitments of the treaties. And the simple answer to that is yes. However, in the context of the Kingdom of the Netherlands, before a treaty can be territorially applied to the autonomous countries, so Aruba, Curacao, St. Martin, they have to first be consulted by the Kingdom government as to whether they would in fact wish to have the treaty applied to them. Now, what's interesting about this scenario is that in the context of the pre the movements to autonomy, Suriname had the treaty applied to it, and then when Aruba became autonomous and was actually on a path to independence that they then stepped back away from, the treaty became applicable to them in 1986. What we have not been able to determine, and I should have stated earlier, I am not a legal scholar, I'm actually a social scientist, and I'm trying to grapple with these constitutional and legal questions using concepts that are familiar to me as a social scientist. So what is unclear to us is why apply to Suriname, why when Aruba became autonomous, it applied to them, but not Curacao and St. Martin. A tentative answer for Aruba is that because it was on a path to independence, normally in our region, when you become independent, one of the signals to the international community is to go and ratify all these treaties. And so as part of that, I am in the international community, I am an independent state. It would have applied the protocol or took on the responsibilities of the protocol. But Curacao and St. Martin have not. So the simple answer is yes, it ought to happen, but they must first be consulted. And what is in this scenario, what is unclear is why it does not, in this instance, apply to Curacao and St. Martin.
Okay, thank you. Thank you for that response. We shall get into the second round. So I can already see we have more questions for Aman. So feel free to take 5 more minutes to respond. Okay, thank you.
Okay, so there are 2 questions, both quite interesting and important for that matter, and I hope I do justice to addressing both in the 5 minutes that we have. To the question of, I mean, it's difficult for me to sort of conceptualize how do we look at the various approaches to solidarity, if I understand your question correctly, Patricia. But what is important for us that we're looking at, and when we're talking about solidarity, or we're looking at this question of like what needs to change, is essentially this idea that anybody who's forced to migrate may have had certain reasons to do so. That idea needs to be respected, and that respect needs to be accorded for whatever reason. Say, for instance, I mean, because we speak about the Rohingya context, I mean, we are talking about the individual struggles that these individuals have to, like I'm not even talking about the questions of journeys that they make, the very resistance that they have with the military junta, or sort of, their interaction with the current central government or the central federal structure that they have is something that needs to be accounted for and needs to be respected. As soon as we accord that respect, I think a lot of concerns sort of start easing out, and that is, and which is where, say, for instance, we need to depart and move away from the structure of the Refugee Convention and look to options elsewhere. The second question, I think, is an excellent one in terms of looking at this very challenging question as to when we're looking at the global south today, though the term itself is kind of problematized, but we're very looking at the questions of global south and generally looking at countries that are sort of showing this, the question of burden sharing becomes a very, very important question as well. But to my mind, for that matter, it's also very important to take note of the fact that burden sharing in itself is, to sort of lay the entire problem on burden sharing is also is a very simplistic exercise. And let me elaborate very briefly on this point, because I feel that in these contexts of these global south countries, which are considered to be sort of poor or sort of hosting the majority of refugee populations, there are post-colonial, there are certain elites. Even in these countries, there is, for that matter, if we look at Tuile's tradition of international law, even in the global south, there are centers of power. And it's very interesting that the Rohingyas, say, for that matter, have been, I won't say that they were living in ideal conditions prior to this government coming into power, but they were, say, for instance, a little better off. These processes against them. So this kind of targeting does not necessarily, of course, burden sharing gives a very easy, for instance, India is not necessarily, of course, like in the Supreme Court of India, the Solicitor General sort of goes ahead and says that India should not be a hub of illegal immigrants or should not be the refugee capital of the world. There are certain tenors to that, and that is the populist vocabulary, which is easy to advance because of burden sharing. So burden sharing here becomes more of a proxy explanation rather than looking at somewhat other factors which are also contributing towards pushing these individuals away. So I hope that sort of answers to some extent the concerns that you raised. But thank you so much for both these questions. If any of you want to jump in, I'm so sorry. I just keep hogging time.
Okay. It looks like the three panelists from concur about the responses. So I would also just love to seek for some clarity from Fitria. You mentioned about the different legal systems in Indonesia. I would just love to know, for example, in the courts, what kind of laws do the courts, do they recognize when they're dealing with these issues? Is it Sharia? Is it the Achinese law? Just to be clear on that. Thank you.
Yeah. First, that as I mentioned before, Indonesia is not party to the Refugee Convention, and secondly, that don't have any kind of legal instruments that recognize or manage the refugees at the crisis. But in 2016, the government adopted a presidential decree, but it's only like for those who came, because it is the experience from Rohingya. So it's like the response of the government's agency in refugee who entering Indonesia in emergency. But it's not about the essential. It's not about the recognition of the refugee rights in Indonesia. It's only like about the technical things, how the UNHCR have their own rules and IOM, etc. But it's not about like the essential, the recognition of the right. So this is the things in Indonesia. So that's why I'm trying to kind of finding out because despite hostility by the shown by the governments, but the people from this context, Acehnese, they could like provide like the effective kind of protection from the refugee. So I would this is my curiosity, and then I would say that actually we are well. I am not suggesting that we don't need legal instruments, but I would like to say that okay, they're still there. There's still values norms that valid. That is like part of this is the living laws. The laws that part of the lives of the Acehnese. They practice it and they recognize it, and they consider it as legal obligation. So I think this is the things that we can underestimate. The presence of any the existence of law other than state law. So this is the things that I would like to kind of highlight in my research. So that the roles of Sharia and also like customary law at the same times. Yeah.
Okay, thank you. We've had really great engagement in the chat. Even the comments, I can see one person whose name, unfortunately, I cannot see, but I think they said in response to Natalie that the issues raise importance of domestic implementation for the autonomous territories to which the protocol applies. I was also wondering in that line, Natalie, might you know of any clear case where there was actually a constitutional dilemma in one of the non-sovereign states in relation to the application of the protocol?
Can you clarify what you mean by
for example, you mentioned the challenges. You mentioned something about the constitutional challenges in most of these non-sovereign states. But I was thinking if there's maybe an example of maybe one case where there's been a dilemma that actually leads to a complication, and that would really lead us more into the human rights-based approach.
Right. So in 2018, I believe, there was a group of Venezuelans that were detained by the government in Curacao, and they were supposed to be deported. And before they could be deported, they were able to make a case that they had not been given the right to ventilate any claim to asylum before a deportation. And they were able to use the European Court of Human Rights, I think it's Article 3 on non-refoulement, in order to actually take the government, the kingdom government, not the government of Curacao, to court in the European Court of Human Rights in order to air this this case. Now, I've been trying to track what's been happening with the case. It started pre-COVID, and the information that I had from the attorney that was handling the matter is that it ought to have been basically like there would have been an agreement between the parties as opposed to a judgment from the court. But it seems that COVID has delayed the proceedings because I have not seen on the website of the European Court any result around this case. But it just reinforces the fact that in the absence of ratification of the treaty, that there are these additional provisions that Aman was referencing in the Indian case. So the European Court on Human Rights, the CAT, and other appropriate human rights instruments that would grant to these asylees the relevant rights that they're due based on their humanity. So that is an interesting case. I am actually keeping track of, trying to see if there is any jurisprudence that will be created as a result of the outcome.
Great, thank you so much again. And that leads us to actually the end of this session. I'm so sorry because of time, we cannot go further, but I would encourage us to reach out to each other. Thank you, Natalie. Thank you, Aman. Thank you, Fitria. Thank you, Ishita. Thank you, Nayantara. Thank you to also Sarah Singer, our focal person, but also most especially to you, the participants, for attending this session. And we look forward to engaging again in other events. So thank you so much, guys.